5 seconds to go. Start. It is further submitted that as observed and held by this court in the case of Dharampal versus State of Haryana and others 2016 4 SCC 160 para 25, the constitutional courts are envisaged with the power to order fresh de novo or re-investigation and as observed and held the commencement of a trial and examination of some witnesses cannot be an absolute impediment for exercising the said constitutional power, which is meant to ensure a fair and just investigation. It is further submitted by Shri Jethmalani, learned senior counsel appearing on behalf of the appellant that, as observed and held by this court in the case of Bharti Tamang versus Union of India and others 2013-15 SCC 578, in case of deficient unsatisfactory investigation, it is the duty of the courts to ensure effective conduct of prosecution, and the courts have powers to direct re-investigation in exceptional circumstances in case it warrants due to deficient unsatisfactory investigation. It is submitted that as observed and held in the said decision, if deficiency in investigation or prosecution is visible or can be perceived by lifting the veil which try to hide the realities or covering the obvious deficiency, courts have to deal with the same with an iron hand appropriately within the framework of law. It is submitted that it is further observed that it is the duty of the court to ensure that full and material facts are brought on record so that there might not be miscarriage of justice. He has relied upon the observations made by this court in paragraph 41 of the said decision. It is further submitted by Shri Jethmalani, learned senior counsel appearing on behalf of the appellant, that even the state has now in the counter affidavit specifically admitted that some further investigation is necessary required on certain relevant and material aspects in the interest of justice under section 173(8) CRPC. It is submitted that now the state has specifically admitted the lapse in the investigation on certain material aspects, and according to the state now further investigation is needed on the relevant aspects mentioned in paragraph 4 of the counter affidavit before this court. It is submitted that therefore also now the state investigation agency of the state may be permitted to conduct the further investigation in exercise of the constitutional powers to do the complete justice to the victim in furtherance of the administration of criminal justice. Shri Tushar Mehta, learned Solicitor General, appearing on behalf of the state, has pointed out certain lapses lacunae in the investigation earlier conducted by the state investigating agency and highlighted the lacunae from paragraph 4 of the counter affidavit and has fairly conceded and even so stated in the counter affidavit that a further investigation in exercise of powers under section 173(8) CRPC is needed required. Shri Shekhar Nafade and Dr. Abhishek Manu Singhvi, learned senior advocates, have appeared on behalf of the respondent numbers 3 and 5 and opposed the present appeal. It is vehemently submitted by the learned senior counsel appearing on behalf of the respective contesting respondent numbers 3 and 5 that as such no case is made out for transfer of the investigation to the CBI, more particularly when now not only the investigation is concluded and the charge sheets have been filed, but even thereafter the charges have also been framed by the trial court. It is submitted that therefore on framing of the charges it can be said that the trial has begun and therefore the case may not be transferred to the CBI as prayed. It is further submitted that even otherwise the allegation of grievous injuries is raised for the first time. Stop.